Hi there, and welcome to Help Solve the Case. I appreciate having you here. I'm Christine Burke, a retired police detective and sergeant, current law enforcement expert witness, forensic genetic genealogist, and investigator. And we are going over the document for the Karmelo Anthony request for a retrial. Now, here on the channel, we look at all things from different perspectives. I love everything court process. I participated in it in a number of ways, starting out as a paralegal when I was a yay young thing and continuing up to today as I'm involved in the court processes. And I think it's very interesting to see what really goes on in these court cases, how the information is presented, and ultimately what happens. I think it has a bearing on all of us, and I appreciate having you here. So let's take a look at the document where we left off. If you didn't see the first one, let me fix my layout here. I wish it would stay like that, but it doesn't. So hopefully that works. Okay. So we have one video, I will link to that, where we started out with the first part. You can see this is a huge document. This is 193 pages. And this is what Karmelo Anthony's defense team is alleging are the reasons that he is entitled to a new trial. Now, starting with Section E, they were talking about public access to the trial proceedings. Okay, so here's another reason. Here's how the defense is elaborating what went on. So they're saying inside the courtroom, 24 public seats and an overflow room provided and then withdrawn. I just want to make sure that I think we might have read that part. Yes, because the grandfather and the aunts were excluded from the trial. That's what they're saying. Okay. For jury selection, the court furnished what its order had never promised. Now, originally they talked about an order, uh, orchestrating the media access, including a what do you call it? A curfew on the parking lot outside the proceedings, which made it hard for people to get in. They had so many family seats, so many media seats, and so many general public seats, okay? And they had an order, and then it seems like they amended that order. So here, for jury selection, the court furnished what its order had never promised, an auxiliary viewing location outside the courtroom, a functioning overflow room where members of the public who could not be seated inside observed the proceedings on June 1st and June 3rd, 2026. Okay? So they're saying, this is the defense, is saying that there was an overflow room for jury selection, but apparently not for the trial. So we might ask the question, why for one and not for the other? Okay? All right. It says on June 4th, 2026, the first day of testimony, the court eliminated it. No announcement was made in open court, no order was entered or modified, and no findings were made. Public access was thereafter confined to the seats inside. Nor was the elimination a reaction to anything that occurred at trial. As early as May 25th, 2026, the public information officer had advised an inquiring journalist in writing, quote, "There will be no overflow room during the trial," end quote. This, although the county's own media request intake form listed, quote, "overflow room access," end quote, among the accommodations that could be requested. When Thelma Anderson asked the court for an alternative viewing location, there was no way to even file the request. The county's electronic filing system had no category for a courtroom access request in a criminal case, so the request was routed by email to the court coordinator and on to the public information officer, and it was denied outside any judicial proceeding. On June 5th, the public information officer confirmed in writing, quote, "There is no overflow room," end quote. All right, now they're talking about day by day. The accommodation existed only while no witness testified. Number 14, The pattern, they're alleging a pattern. The pattern is visible day by day. During jury questionnaires and voir dire, June 1st and June 3rd, an auxiliary viewing room accommodated the members of the public who could not be seated inside. On June 4th, the first day of testimony, that room was eliminated, and on every documented day of testimony thereafter, members of the public were excluded. The accommodation existed precisely when no witness was testifying and vanished precisely when evidence began. Okay, and they have a little chart here, okay, describing it. We're not going to go into detail there. G, the excluded public. 15. The exclusions that followed were repeated and concrete. Jacqueline Yawn traveled from North Carolina and on the first day of testimony found a line of roughly 80 to 100 people, from which only about 27 were admitted. Tira Allen flew in from Arizona, observed jury selection from the auxiliary viewing room, was told on June 4th that the room had been eliminated, and was excluded from the courtroom on June 4th and June 5th. Bridget Smith attended on June 1st, 4th, 5th, and 6th, and confirms both the roughly 27-seat public cap and the elimination of the outside viewing location once testimony began. I don't know if I can say this right. Kieria West was turned away on June 1st on a purported, quote, jury members only, end quote, rule, and was physically removed from the courthouse on June 6th because of the expressive content of her clothing. Thelma Anderson was excluded on June 4th and June 5th, and on June 6th was seated only in mid-afternoon after substantial portions of that day's proceedings had passed. Throughout, no declarant, those are the people that are coming forward, observed any disturbance, security incident, or disruptive conduct by any member of the public that would explain the restrictions. H, the unrecorded agreement. The defense tried its case under that limitation in reliance on an understanding reached off the record. The same off-the-record method that hid the pretrial proceedings from the public also produced the understanding on which the entire defense was built. Now, in the first video, they talked about stuff about some agreement, things that were done in chambers that appear to be not recorded, and that's what the case was built on, and that the public had no access to that, okay? So I think they're going to start talking about that. Beginning in early May 2026, the lead prosecutor proposed that the parties, quote, try the case clean, end quote, based only on what happened under the tent that day, end quote, with neither side offering character, reputation, or extraneous conduct evidence concerning either the Metcalf twins or the defendant. So it sounds like, I've never heard that try the case clean, means that maybe, I'm guessing, they were just going to stick to the facts instead of trying to impeach witnesses because they're talking about character, reputation, or extraneous conduct. They were going to narrow it down to exactly what happened under the tent, okay? That's kind of what it sounds like. I don't know what you think, let me know, but that's kind of what I'm seeing. So they're saying now that they negotiated this agreement in meetings and on calls on May 5th, May 8th, May 11th, and May 21st, 2026. And they presented the understanding to the court itself in chambers off the record. Okay, that means the judge. To avoid media reporting on, quote, bad act, end quote, evidence, the understanding was memorialized only as a deliberately generic motion in limine hand-delivered to the court on the first day of trial. It does not appear on the public docket. Now, I'm not sure what that means, but I think what they're trying to say here, like what happened was they were saying they didn't want to put it into the document about, instead of saying that so-and-so did this and so did that, we're only sticking to this, right? So they didn't want to formalize it in writing because the media would have taken advantage of that. That's what I think they're trying to say, but I'm not sure. So they said it was a deliberately generic motion in limine. Those are done right before trial, hand delivered to the court on the first day of trial, and it does not appear on the public docket. So I'm not aware. What happens to that? Doesn't everything have to be on the docket and part of the court record? I don't know. What do you think about that? Okay. From that point forward, the defense tried its case under that limitation at every stage in reliance on the bargain, meaning they were only going to stick to the facts, not what could be typically termed, and again, I'm assuming here from what the document says, character assassination, reputation, prior bad acts, all things like that. Only what transpired, okay? So here, they're elaborating. In voir dire on June 3rd, the defense did not explore with the panel, that's the jury panel, the themes of the decedent's character and aggression it otherwise would have developed. In its opening on June 4th, it introduced none of them. Okay, when they did their opening statement, they didn't put that in there. Through the state's case on June 4th, 5th, and 6th, the defense let the state's student witnesses leave the stand without confronting them with their own recorded statements to police that Austin Metcalf was, quote, kind of like the aggressive guy on the team, end quote, and that he, quote, got triggered, end quote. That, quote, Austin and Hunter, they're not going to let you disrespect them, end quote. That, quote, if Austin is about to get into a fight, you can tell, end quote, and that he could be, quote, a bit aggressive at times, end quote. And in an abundance of caution, even narrowed the questioning, the understanding permitted. Okay, so if you guys have watched trials, you see how they bring witnesses in to testify, character testimony, different things. Well, if they've done this, right, because they want the jury potentially to think, whether it's the defendant or the state's witness or even the victim, right? We see cases where we've heard the victim is on trial. Well, they did this. Well, they did that. And I'm not saying this here. I'm just giving an example. We're looking at all sides of this. We've heard certain things, and don't trash me on this. I'm just giving a perspective. The victim deserved it, right? The victim never deserves it, okay? Right? If they're the victim, they don't deserve it. But victims have been characterized in certain ways, okay? Trash the victim, trash the defendant, trash the witnesses. It's impeaching people's character, and that is part of the case. So what it sounds like here to me is the defense, from what they're arguing here, they thought that they had agreement, like a clean fight, okay? They're not going to dirty fight. So they're not going to disparage the witnesses and do all that stuff. Maybe they made that in an agreement because they already knew that it was a hotly contested case. I don't know. I'm just thinking out loud. Okay, that's what we do here. So you're welcome to think in the comments. All right. So apparently, from what the defense is saying here, the witnesses gave recorded statements to the police about witnesses and victims' character and past actions and likelihood, okay? If you were on trial, do you think that that should have been admitted or not admitted? Would you want, right, if you were the victim's family, would you want the state to talk about that, right? Like we're talking about in other cases, things get withheld. All right. And the jury, we hear the jury so many times say, I wish I would have known that. All right. But during all this pretrial stuff, like we saw we're seeing in the Charlie Kirk case, argue, get it in, don't get it in. Okay. So if you were the victim, would you want the defendant's character and all that stuff to be brought in if you felt that it contributed or gave a visual perspective of the defendant? I'm assuming you're probably going to say yes. So the same way when we step into the defendant's side, if there's stuff on the victims or the victim's witnesses, wouldn't you want that brought out? I'm thinking you're going to say yes. So here, it seems what I'm reading, and please let me know if you interpret it differently, that they agreed to a clean fight. Maybe that's what they're talking about, a clean fight, that they're not going to character assassinate people, even though it was on the record and in the discovery, or it was maybe not on the record, but it was in the discovery. So it was available to the defense. Now, does that go to ineffectiveness of counsel? Maybe. I think the defense team changed. Does that go to ineffectiveness of counsel because they made this agreement? If you're a defendant and your life is on the line, you know, do you want the best defense possible? Okay. I don't know. Okay. So anyway, all right. Now, the defense designated no experts, foregoing a neuropsychologist prepared to explain how the defendant's epilepsy affected his perception of threat, and a forensic psychologist prepared to address adolescent brain development and the fight or flight response, because the state took the position that such testimony would breach the understanding. Now, let me tell you, the American Bar Association criminal defense standards, I know because I'm an expert, right? I testify as an expert. They're pretty specific about the use of experts and when the attorneys should call in experts if they are not subject matter experts. If you haven't read that, maybe that's something we can go over if you want to go. It's on the ABA's website, and I believe it's called the Guidelines for Criminal Defense Standards. It specifically talks about experts and the use of experts if the attorney is not knowledgeable in that area. Okay, so do we have an ineffectiveness of counsel issue here? Okay. It says the forbearance had a purpose. The payoff was to come in the defense case, under the understanding, as the prosecution itself repeatedly described it, covering all witnesses to, quote, what happened under the tent, end quote, the defendant would testify to the altercation like any other tent witness. It says the defendant would testify to the altercation like any other tent witness, free of character impeachment. There you go. And the defense would present its self-defense case through him. Okay, so it sounds like the reason that certain witnesses don't get on the stand and defendants don't get on the stand is because it becomes a wide open free-for-all on what they can talk about, what the defense and the state can ask about, okay? Free reign. So with this agreement, they were only going to, they apparently agreed in front of the court. That's kind of what it sounds like. Again, I wasn't there. I don't know. Don't shoot the messenger. They're saying that he was going to testify, and they were sticking to just that time of what happened under the tent, okay? Free of character impeachment. And the defense would present its self-defense case through him. They say every pretrial discussion presupposed it. The prosecution repeatedly raised the ambiguous aggressor doctrine, whatever that is, doctrine that matters only in a self-defense case built on such evidence. And as trial counsel has sworn, in this case, the defense would ordinarily depend on the defendant's own account of his perception of the threat. And I want to get to that, but I want to reference something that I had talked about previously. And again, we're not on one side or the other. We're examining the chess game that was the court proceeding. Okay. In the previous video, I talked about the fact that I even showed the constitutional charge for provocation. I forget what it's called in Texas. But I showed that. And it applied potentially to Metcalf. And I wondered why that didn't come up. You can go watch that video. I said, this is weird. Why is this not coming up? Why is this not being talked about? Okay. And potentially That's because this agreement. I'm just asking the question, was this because this agreement? You know, so they're also talking about here the defendant's own account of his perception of the threat. And I might have talked about this too, that when it comes to law enforcement officers, they talk about what a reasonable officer would have done and what the officer was perceiving at the time. For instance, me being of a different size and stature compared to a bigger officer, that my use of force level may be different because of a perceived or real disadvantage. It comes down to the perception of the officer at the time. Somebody made a comment they didn't like when I was talking about perception, but it is perception, okay? So there, the defense here is talking about the defendant's own account of his perception of the threat, what he believed happened, and his notion of that he had to how big the threat was and how he had to defend himself, okay? Then they say, on Monday, June 8th, the final day of evidence after the defense had spent voir dire its opening, the entire cross-examination of the state's case, and the first day of its own case, honoring the bargain, the lead prosecutor announced that the agreement had, quote, never contemplated a testifying defendant, end quote, and asserted that defense counsel had already, quote, opened the door, end quote, by mentioning in opening that the defendant played chess, a position the court itself rejected. Let me read that again. Okay, so opening the door means, remember when I said everything is fair game? If you open that door, you can't shut it again, okay? So that means what they're saying here, when the prosecutor said that the defense opened the door, that means, according to the prosecutor, if he goes on the stand, everything is fair game. Now, I'm trying to understand what the playing chess has to do with it, and I'm trying to understand what they're saying here. A position the court itself rejected. I'm not sure the way that sentence is written that I understand it. The court then advised the parties that it knew of no mechanism at its disposal to enforce their understanding. Uh-oh. Not in writing. Uh-oh. And understanding that throughout the months the defense relied upon it, existed on no record, and because it had been reached and presented to the court off the record, always get in writing, and that if the defendant testified, the door to character and extraneous defense evidence would almost certainly open. Okay, so the court was saying, look, I don't have any mechanism. I don't have any way to enforce this understanding. And the defense is saying that through the months, the defense relied upon it. It didn't exist anywhere. It was off the record, but the court is saying if the defendant testified, the door would be open. Like I said, you can't shut that door. Allotted 10 minutes to make that decision, the defendant elected not to testify. By then, it was too late to conduct a different voir dire, deliver a different opening, or recross the state's witnesses. And at punishment, maybe you should have preserved the witness. Maybe they, again, ineffectiveness of counsel, I don't know. Maybe they should have preserved the witness. And at punishment, the defense case was reduced to three pre-approved questions of the defendant's mother. The state, for its part, called no punishment witnesses and offered none of the extraneous offense or character evidence cataloged in its 75-page notice, resting its punishment case immediately, exactly as the lead prosecutor had described on May 11th that the agreement would operate. So it sounds like they're saying here, look, the defense thought that they were going for it because they They didn't they didn't call a punishment witness. They offered no the extraneous offense character evidence in the notice, and they rested the punishment case immediately. Okay. The state thus performed the bargain at punishment the day after denying that same bargain covered the defendant's testimony. So I don't know. It sounds like someone saying one thing, someone saying the other thing, and they're could be whipping it out whenever it's appropriate. I'm not sure. In the end, says the defense, neither side put on the character evidence the understanding covered. The bargain was performed on both sides through the last day of trial. The only term repudiated was the one most vital to the defense, the defendant's own testimony. So does that make sense? So they're saying that they had this agreement. It wasn't written down anywhere. They said it in front of the judge. Then they get into court. The state seems to be following the bargain. Then all of a sudden at the last moment, the state says, because you said this in your opening, the doors open to full disclosure, which could create jeopardy. And the court said, yes, I don't have a mechanism to fix this. So, he could be fair game. And the defense had to decide in 10 minutes. So they said it only came up in that one section, and they had to make the decision not to have him testify. But because he was going to testify to certain things, they didn't bring out possibly the information he was going to testify about through the other witnesses. Does that make sense? So it's kind of like, if you're the member on the team and, and let's just say you can hit the home run, but you don't get up to bat and your team needs, a home run and you lose the game, it's because you didn't have a chance at bat and you thought the whole time, right, that you were going to get to be at bat. You're the star hitter, right? So maybe that will explain it, okay? So it says Karmelo Anthony was necessarily a witness to what happened under the tent. Under the understanding, as the state itself had repeatedly described it, he would testify like any other tent witness, and his elimination as a witness was devastating to a defense that turned on its own perception of the threat he faced. By then, the defense had already paid the price of reliance and could not undo the voir dire, opening, cross-examination, expert designations, or decision framework that had followed from the understanding. So the voir dire is the jury voir dire. So if they're going to talk about this character and impeachment and prior bad acts, like they might have said something, they might have asked a question like, do you think if somebody has a history of, I don't know, I'm just giving a random thing. If somebody has a history of battery, they got in fight, and this is a young guy, so it's not the same thing. But if somebody has a history of battery in school, do you think 30 years later, that would show a pattern of a domestic violence or something like that, right? They're going to ask what the jury members think about character and stuff, things that have happened in the past to a person, and would that affect their view on the incident, okay? But because they thought that none of that was coming in and he was testifying, they didn't ask those questions, all right? None of that, okay? They didn't ask any of the witnesses. They didn't mention certain things in the opening, all right? They didn't put on the experts or anything because they built, they had their plan of attack and it was supposed to unfold the way it did. They had their battle plan, okay? They thought it was an air assault and it became a ground assault and they didn't have any troops on the ground, in essence, okay? The expedited schedule, Saturday court and 10 minutes to decide. The trial itself was run at speed. Yes, it was very quick, I think, very quick. At the May 29th conference, the court announced its intention that the defense begin calling witnesses immediately upon the state's resting so that no trial day would go unfilled. including Saturday, June 6, 2026, a day on which several defense witnesses were unavailable. Trial counsel told the court that the schedule could force the defense to call the defendant out of order. And why would you not want that? Why would you not want to call the defendant out of order? Because you want to set the stage. You want to get all your ducks in a row before, right? Like the play, you don't see the end of the play before the beginning of the play. Everything leads up to the conclusion, right? Okay. So, it says the state rested midday Saturday and the defense began its case that afternoon. The repudiation of the parties' understanding, described above and set out fully in Part 4 below, erupted, that's a big word, on Monday, June 8th, the final day of evidence, when the moment came for the defendant to make the most consequential decision of the trial. And yes, testifying as a defendant in your case is a big deal, specifically because you're wide open. Okay. Again, not an attorney, but ask an attorney about that. Usually it's okay. Whether to waive his Fifth Amendment privilege and testify, the court allotted the defense 10 minutes to counsel a 19-year-old through it and denied counsel's request for additional time. I hear this a lot. People pressured to make a split-second decision that will end their life, right? You know, on a different side of this, people ask about police officers, military people, all kinds of professions having to make split-second decisions, and then people come and Monday morning quarterback it, right? But if your life was potentially on the line and you thought that you were, I don't want to use the word safe, but you're going down this track, right? And now you have to step in front of this train and you have 10 minutes to decide. And he's 19, right? Again, not on one side or the other. We just have to take for a moment our perspective, put ourselves in his shoes, and he has to decide 10 minutes. You know, what is that Jeopardy? Play the Jeopardy music, okay? Because it is Jeopardy. It is Jeopardy. All right. The defense rested that day after the shortened session, and the jurors were sequestered overnight in a hotel, informed if they didn't reach a verdict on Tuesday, they would remain sequestered, and they don't like that. They don't like it. You wouldn't like it. Nobody likes that. On Tuesday, June 9th, unless someone has some bad home life and they like staying in a hotel and getting away from it all. I don't know. On Tuesday, June 9th, 2026, the court delivered its charge. That means they gave the charges to the jury. The parties presented closing arguments, and the jury deliberated approximately 3 hours before finding the defendant guilty of murder. The punishment phase, evidence, argument, deliberation, and the rejection of sudden passion was then completed, and the 35-year sentence imposed before the day ended. The sequestration and deliberation chronology, widely and publicly reported, will be established at the hearing and confirmed by the reporter's record. I think they asked for a hearing on this, so I think that's what they're talking about. After the verdict, the sealed file, the missing record, and the televised defense of the closure. The secrecy outlasted the verdict. Again, these are defense words. Trial counsel withdrew on June 10, 2026. Appointed appellate counsel was then replaced, and present counsel were substituted in on June 23, 2026. All while the 30-day deadline for this motion ran, the reporter's record remained wholly untranscribed, and the pleadings and case file sat in the court chambers rather than in the district clerk's public record sealed by an oral order. Now, this is a huge statement. Let me try to explain why they're upset about this. So trial counsel, okay, so Whether or not, I don't know, but I've talked about potential ineffectiveness of counsel, right? Claim. So on June 10th, the regular trial counsel withdrew. Appellate counsel was then replaced, court-appointed appellate counsel was replaced, and then present counsel was substituted on June 23rd. So the new counsel only came in on June 23rd. What is that? 13 days. Okay. And they had a 30-day deadline to file this motion. Okay. Motions for new trial, like these things take, this is 193 pages. Ask any attorney, like this is like, okay, so they had, what is it? 17 days? Is that 17 days-ish? To get up to speed and file this dang thing, because they only had a 30-day deadline. And, okay, so not only was, who knows if the original trial counsel talked to the original appointed appellate counsel, who then got substituted for these people, did they even talk together? Then the court record was untranscribed, and the case file sat in the court chambers instead of the public record where they could access it. Okay. They're saying here at a conference on June 29th. Okay. So maybe they've got June 10th, June 29th, they've got how many days is that? 19 days. So they've got like 10 days left, maybe. The court advised that the entire court file had been sealed by oral order and conditioned counsel's inspection of it on an agreement not to disclose what he observed. A condition counsel could not give, leaving the file available only in chambers. So I don't know, did they have to go in the remaining days? Did they have to go sit in the chambers to view it? Did they get to view it at all? I mean, attorneys would be like, heck no, like, can't be done. All right. 2 days after imposing sentence, the trial judge gave a televised interview defending the restrictions that they talked about earlier, describing the decision to bar cameras and streaming as, quote, an easy decision, end quote, acknowledging that he, quote, sometimes ... thinks maybe he should have ... at least ... audio stream or something so people could hear it, end quote, and explaining that he declined to do so because, quote, people are gonna distort whatever happens, end quote. So, quote, what's the point, end quote. I don't know about the media laws, but the point is the law, whichever way it goes, right? That's a kind of weird statement. Okay. In a written statement to Fox News, the judge added, quote, now that the trial is over, it's important for me to provide transparency. I don't mean to laugh at that. Sorry. It's important to me to provide transparency. I think, I could be wrong. I think that the transparency is supposed to go on during the proceeding. Just saying, okay? And in a public letter of June 17, 2026, he thanked the other judges of the county for adjusting their own dockets to accommodate this trial, at minimum raising a fact issue about available courthouse space, available staffing, and available alternatives that should have been considered before the overflow accommodation was withdrawn. So I think they're saying something there. I don't know what the public letter is or whatever, but it sounds like the defense is saying there might have been, because of what the other judges adjusted their dockets and the courthouse space, there might have been another courtroom open for overflow or something like that. I'm not sure. Because the reporter's record of the trial has not been prepared, the official court reporter has advised counsel that no portion of the trial has been transcribed. AI people. And because the case file has been held in chambers rather than in the district clerk's public record, the recitation above is drawn from the indictment, the court's charge, the public docket, the court's own orders and public statements, the attached affidavits and declaration, and counsel's knowledge. Defendant will offer evidence at the hearing in support of the grounds timely raised herein. So they don't even have the record. I don't even know if any of these attorneys were present during the trial. And they had to whip this puppy out in 30 days. Again, not one side or the other, but I don't think you guys understand. Some of you might. This is a Herculean effort. And hopefully they got it right because they don't have access to anything, it seems. Okay? Crazy, crazy stuff here. Okay. So I'm going to end this here. I'm going to try to keep these concise. We're going to keep cycling through these. I want to thank everybody that subscribed to the channel. We made our initial number. I am so grateful. Thank you so much. I love all your comments. I try to do my best to answer them. Sometimes I miss them. You guys raise great points. I'm going to keep going. Let me know what you'd like to see, what you don't like to see. I'll do my best. I do want to add that in addition to doing this, which I love, I do work full time. I work in 2 areas. I support clients as an expert witness, and I support law enforcement in identifying our unknown human remains. So, please understand that I do the best I can. Sometimes I can't put clips and different things like I would like to, but I'm doing my best to get you the information as timely as possible, and with as much explanation and as much as my take on it as possible. So thank you for being here. My goal is ultimately to resolve the over 15,500 unidentified human remains cases across the United States, give them their names, and clear the hundreds of thousands of cold cases across the United States. And I can't do it without you. I will see you on the next one.